More than a dozen states and a number of pro-life groups are asking the Supreme Court to weigh in on so-called buffer zones around abortion clinics. The case involves a Catholic woman banned from offering counseling outside of an abortion business in New York. Texas, Alabama, and Missouri are among the states signed on to a brief saying they support free speech outside of abortion businesses. And joining us now is Andrea Picciotti-Bayer, EWTN legal analyst and religious freedom expert. Andrea, always so good to be with you. Let's start off talking about this case and the significance of it, especially since so many states and organizations joined the Amicus brief.
Well, Tracy, thanks so much for having me on. It's always great to join you. I think this is a really important case because it is going to be a marker for post-Roe America. For so many years, the Supreme Court has kind of been handicapped because of Roe versus Wade and Planned Parenthood versus Casey in trying to manage other important constitutional rights that are specifically mentioned in the Constitution, like free speech. This case in the lower courts was bound by some precedent that was in the year 2000, where there was allowing state laws and local laws to create a buffer or a bubble around abortion facilities where people wouldn't be able to communicate and interact as normal free Americans can do. Now the court is going to be able to, if they choose to take up this case, revisit that issue and hopefully recenter back in the important free speech rights that are part of our American tradition.
Yeah, and I was going to ask you that, Andrea. I mean, what type of impact do you think this will have on the Supreme Court, that is, and for them to take action?
You know, I think that the Supreme Court is very attentive to what's happening after its Dobbs decision and revisiting issues. Already, Supreme Court justices have commented that they thought that that 2000 decision that this case was governed by was incorrectly decided, and they're interested in righting the wrong that was done in that case. I think it's also an important indicator for how important it is that we continue to push for creating a culture of life. So even beyond the legal issues involved, the ability to meet people where they are, especially if they're considering issues of pursuing an adoption, that oftentimes is best met with a loving word and a kind direction to alternatives to the gruesome act of aborting their own child.
Yeah, I want to turn to another case now in Montgomery County, Maryland, where people from many different faiths filed a lawsuit against the school district because they wanted to opt their children out of the LGBTQ curriculum. Tell us more about that and where things stand right now.
You know, Tracy, this is a really exciting case. This is an across-the-board response of parents in Montgomery County, Maryland, just a stone's throw away from our nation's capital, who have objected to the inclusion of a series of books called an inclusivity series that addresses issues of same-sex attraction, gender identity, and different issues related to human sexuality into the youngest students, pre-K through 8th grade. The parents just want to exercise their right to opt their children out of being exposed to those series of books, and the school board in Montgomery County has refused to allow them to exercise that right. The parents lost in the lower courts, and just yesterday, Beckett Law, representing this group of parents, filed an appeal to the 4th Circuit Court of Appeals. I think that their case is strong, and I think that we're going to be seeing more and more cases like theirs across the country as more and more parents get interested in what's going on in the classrooms and exercising their rights as parents.
Yeah, we're going to keep an eye on that case for sure. Before I let you go, we have a minute or so left, Andrea. But another case that's garnering a lot of attention involves Southwest Airlines requiring their lawyers taking religious freedom training after firing a pro-life employee. What is the latest on that, and also the larger implications of this case as it relates to corporate America?
You know, Tracy, I think it's very interesting. The lawyers representing Southwest Airlines were given a directive from the district court judge, Starr, to make sure that their employees knew that they're protected against religious discrimination. And this was in the context of a case where a woman was fired for expressing her pro-life positions and opposing the airline's reimbursement for employees in the union who had attended a pro-abortion protests here in Washington. Those lawyers failed to take the directive of the judge seriously. Instead of reminding the employees of their religious freedom rights, just said, make sure that we're all very civil together. And the judge had no other recourse but to order them to go back to school and ordered them to take religious freedom training, directing it to be provided by Alliance Defending Freedom, which is a very successful Christian religious liberty law firm. It's unique. It's a unique order. But in looking at the history of this case, you can really see that the judge was very frustrated with the failure of the airline's lawyers to follow his rules. And sometimes you just need to go back to basics.
Well, Andrea, thank you so much for coming on today. Always appreciate your insights. Really important. God bless.
Thanks, Tracy.